Welcome. Thank you to the Apprenticeship Employment Network for hosting the National Skills Week Industry Workshop. Never before has skills reform been more critical to our nation. Ensuring our workforce has the skills we need for the jobs of the future is critical for rebuilding our economy, especially in the post-COVID environment. Collaboration between government, industry and the community will be vital to the success of our recovery. And it goes without saying that the Morrison government is committed to supporting Australians to stay and work. However, we also need Australians better trained for the jobs needed. And to do that, we need real reform when it comes to skills training in Australia. So we have prioritised skills development as part of the JobMaker strategy, which is designed to set Australia up for the economic success over the next 3 to 5 years. Our multi-billion skills package provides a significant boost to the vet sector. This includes our supporting apprentices and trainees wage subsidy that is providing timely, targeted and scalable support to businesses to keep on their existing apprentices and trainees. This builds on the establishment of the National Careers Institute and the National Skills Commission. These two organisations are working together to strengthen, streamline and improve the delivery of and access to careers information in Australia. Again, I'd like to thank the Apprenticeship Employment Network for hosting this industry workshop, and I hope that you enjoyed today's session. Thanks.
Welcome, Janet.
Good day. Thanks, Gary. Just get my screen sorted out. Okay, so today I thought it'd be useful for us to get my screen working. Okay, to go through some of the JobKeeper changes that occurred to the Fair Work Act going back to March, April, and there are also some extensions of those provisions that are before the Parliament at the moment. So I just want to go through again what those JobKeeper changes are and how they should be implemented properly so that there are no repercussions when we come out of the JobKeeper arrangements. There have been also some JobKeeper changes to awards, so I'll briefly go through those. I'll quickly go over the annual wage increase for 2020 because it was slightly differently constructed this year to previous years. For those GTOs who have labour hire parts to their organisation, I'll talk a little bit about a decision that's been made about casual loadings and just the continued process of updating modern awards to transfer them into 2020 awards. So they're the things that we'll cover today, and then hopefully at the end we'll have some time for questions. So just going to the JobKeeper changes to the Fair Work Act, these changes apply to employers who meet the eligibility criteria for JobKeeper payments. The stand-down provisions of the Fair Work Act are still available to employers who don't meet the eligibility criteria for JobKeeper. So there is still a capacity to use the usual stand-down provisions where an employee can't be usefully employed for a reason that's outside the control of the employer. So just limiting ourselves today to the JobKeeper changes to the Fair Work Act, there are two elements to these changes. One side of the changes is to provide that an employer can give directions to an employee, and the second part is that the employer can make requests of employees. So there's slightly different arrangements that apply because the first one is a direction that is enforceable. The second one is an agreement that has to be reached between the employer and the employees. But I'll get to those as we go through. So the directions, they enable an employer to make JobKeeper enabling directions to employees who are receiving JobKeeper payments. And there are three particular parts. There's a reduction in hours or days of work, including reducing the hours or days to nil. So that's where you would have a complete stand down. Directions to undertake alternative duties and directions to work from an alternative location. and that was really to facilitate, in general, people being able to work from home. The other side of the changes allows an employer and an employee to agree to variations to the days of work. So that is to work on different days and at different times to their usual hours or days of work. And this is different to a reduction in hours of work. So you might not be reducing their hours of work, but you might be saying, instead of working Tuesday and Thursday, can you work Tuesday and Wednesday or Monday and Wednesday, for example? That has to be by agreement, as opposed to the capacity to direct somebody to reduce their days or hours. The other element of agreement is taking annual leave at half pay. So you can make a request for an employee to take annual leave, and that could be at half pay. So the variation to work arrangements, these apply when an employee cannot be usefully employed for their normal days or hours because of changes to the business which are attributable to coronavirus and associated government initiatives, such as a particular type of workplace might have been closed down. For example, the restaurant industry in Victoria. So these reductions, employee can be directed to not work on particular days they would ordinarily work. So as opposed to a stand down provision under the Fair Work Act, which is usually a complete stand down, you can actually say instead of working full time, you can work 3 days, or being directed to work 3 days a week. So you could say, we're not requiring you to come to work on a Friday, for example. And some of the arrangements that we've seen in some industries is that the shifts have been worked up into 2 different shifts, so that if coronavirus there was an outbreak of coronavirus in one shift, that the other shift wouldn't have been affected because they're working alternate weeks. So that's a direction that you could make under these provisions. Work for a lesser period than they would ordinarily on a particular day. So instead of working 8 hours, they could be directed to work 5 hours, and work a reduced number of hours overall, which can include reducing the number of hours to 0. That's a complete stand down. So the variations to work arrangements, there are some employee protections within the arrangements. Employees don't have to comply with a direction if it is unreasonable in all the circumstances. And I'll get to some dispute decisions shortly, which will talk about the unreasonableness. Employees subject to a direction, particularly where they've been directed to reduce their hours to 0 or other reductions in hours, can ask to engage in secondary employment, training or professional development. And employers have an obligation to consider these requests and can't unreasonably refuse them. So that's where, if somebody's been stood down, they're on the basic JobKeeper amount of $1,500 a fortnight, they might have an opportunity to be able to supplement their income through secondary employment, and that's something that the employer has to consider. So other JobKeeper enabling directions, they can give some other directions if they believe that it will assist in the continued employment of their employees, and these are alternative duties. So an employer can be requested to perform any duties within their skill and competency, and you can see from the notes that provided the duties are safe, reasonably within the employer's business operations, and the employer is competent and licensed to perform those duties. So an employer couldn't say, well, I've got another business on the side, which is a completely different industry, and I want you to go and work in that industry or in that other side business. So it has to be reasonably within the scope of the employer's business. But that allows a broader range of duties to be encompassed by a particular employer where their position description might limit what they would normally be asked to do. And that's probably more relevant to labour hire than to apprentices and trainees, but could equally apply in that situation. Alternative location, so an employer can direct an employee to work somewhere other than their usual place of work, including their home. And again, there are some protections in there that the location has to be suitable for the duties, doesn't require unreasonable travel if it was going to be an alternative work location. and that the employer's duties are safe and within the scope of the business operations. And this is an issue that sometimes comes up about working from home, is that there are health and safety obligations that can apply where an employee is working from home. That those obligations existed prior to the JobKeeper arrangements, and they continue through this and are reinforced by these changes to the legislation, that the employee's place of work must be safe, including if that's at their home. There are some other issues that arise from working from home, and that relates to payment of expenses, providing equipment, and that sort of thing. So those things should all be discussed before somebody's working from home, to make sure that you don't get any surprise invoices for energy usage and the like after the event. Agreements to vary the days of work. So these are the two areas that I referred to at the start, where they are not a direction, they are a request. So employers receiving the JobKeeper payments can request an eligible employee to work on different days and times to their ordinary days or hours of work. This is asking them to work different days and times, not reduce their days and times of work. And again, provided that it's safe and within the scope of the employer's business operations. Agreements re annual leave, and we've had a fair number of inquiries about this aspect. Employers can request an eligible employee to take annual leave at full pay, providing they have at least 2 weeks of annual leave remaining. So this is different to an employee under an award, where if they've got excessive leave, you can ask them to take some of their leave and reduce it to 6 weeks. This is a much more flexible arrangement that allows an employer to direct an employee or request an employee to take annual leave, but they have to have 2 weeks of annual leave remaining. Employers and employees can also agree to taking annual leave at half pay for twice the time, which is not a provision generally provided for in awards. So agreements to vary the days of work and the annual leave. The employee must consider such requests from their employer and must not unreasonably refuse the request. The employee cannot be directed to take the annual leave or work on different days or different times, but has to reasonably consider the request. If an employer thinks that an employee is not reasonably considering that request, they can trigger the dispute mechanism through the Fair Work Commission. And I'll go through some of those dispute decisions shortly, and you can see some of the outcomes there. If you've got somebody who is receiving or on JobKeeper stand-down provisions, the period of service still counts as service for all purposes. So you could have somebody on 0 hours, but they continue to accrue leave during that period. So that's personal leave, annual leave, long service leave, etc. It counts as if their normal hours were in place. Public holidays which occur during the stand down have to be paid for, so but only the days that an employee would normally have worked. So for a part-time employee, if they didn't normally work that public holiday, they wouldn't get paid for it. But if they work that day and they're stood down, they have to be still paid for that public holiday. A decision that was made by I think it was the Fair Work Commission or the Federal Court about the use of personal leave. This arose when Qantas employees were who were already on personal leave were trying to use their personal leave on a stand-down day. The decision was that they can't use their personal leave if they've been stood down from employment, but they can elect to take annual leave. The rates of pay, so if an employee's been given a direction to change their duties and there's a higher rate of pay that would normally be associated with that work, they have to be paid the higher rate, and they have to be paid any applicable penalty rates or allowances that would normally apply to any hours that they work. So all of the award provisions are still in place for the hours of work that are worked. Employees receiving the JobKeeper payment, the hourly rate of pay for hours that are worked can't be reduced by a JobKeeper enabling direction. So for any hours that they work, they still have to get a minimum of their hourly rate. And if they're getting, if they're working an hourly rate that means that they're getting more than $1,500 a fortnight, then they will be getting paid more than the JobKeeper amount, and the JobKeeper will subsidise the first $1,500. So you can't say to somebody, you are earning $2,000 a fortnight, we'll continue to require you to do your normal 38 hours, but we'll only pay you $1,500 per fortnight. They still have to be paid their normal hourly rate for each ordinary hour worked. So that's the point I've just been over there, that if they're entitled to more than $1,500 per fortnight, then they have to be paid the full amount for all of the hours that they've worked. Superannuation is payable on ordinary hours worked. So if an employee has been stood down and their hours are 0, there won't be any superannuation payable on the JobKeeper payment. But for any hours that they do work, then superannuation is payable. The JobKeeper arrangements require that there's consultation before you enter into a JobKeeper or issue a JobKeeper direction. So the employer, firstly, they can't misuse the JobKeeper direction, and this has been reinforced in the amendments that are being proposed to the legislation at the moment. And the employer has to consult with the employees at least 3 days prior to the direction being given, but an employee can agree to a shorter period of consultation. And really importantly, the JobKeeper direction has to be provided in writing. And the Fair Work Ombudsman has got some template arrangements on their website for a consultation arrangement and for a JobKeeper direction. So if you need to issue a JobKeeper direction, that's a source of information that you can use to issue the direction. I'm concerned that some GTOs haven't actually provided the directions in writing, and the consequence of that may be that down the track, I think there'll be some law firms that are out assisting employees to recover payment of wages where they haven't been given proper stand-down directions in writing, and they should have continued to have been paid their full wages for the period. I would imagine that most apprentices and trainees are paid less than $1,500 per fortnight, so it might not be an issue, but it could be an issue for labour hire or other operations if the stand-down provisions haven't been properly processed in writing. So disputes. The Fair Work Act changes allow the Fair Work Commission to deal with disputes that arise from the changes to the Fair Work Act and the JobKeeper enabling directions. And the Commission can mediate, conciliate or arbitrate as it sees fit, and it can issue orders that uphold, set aside or vary a JobKeeper enabling direction, or make any other orders that they consider appropriate. And I'll see in some of the cases that has occurred. The Fair Work Commission can hear disputes about those items that are listed, so the temporary or partial stand downs, temporary changes to the employer's usual duties and locations of work, agreements about altering the days and times of work, agreements about the use of annual leave, and employer requests for secondary employment and training. So the example of an employer requests to use annual leave and the employee refuses could be resolved by taking a dispute to the Fair Work Commission. And I think the Fair Work Commission is trying to list and hear those disputes within 48 hours of the dispute being lodged. They can't hear disputes about JobKeeper eligibility. That's something that has to be referred to the ATO, or about JobKeeper payments. It's not within the remit of the Fair Work Commission to hear disputes about the actual payments of JobKeeper. So just looking at some of the dispute decisions so far that the Fair Work Commission has dealt with. The decision in one case was that it was unreasonable to only reduce one employee's hours to 0 and to not share the reduction in hours amongst a team. And the Fair Work Act changes and the changes that are being proposed for the extension of these arrangements specifically require that that one employee can't be treated unfairly compared to others. So there's a reasonableness assessment that an employer has to go through in saying, well, if we've got to reduce hours, how are we going to share the burden amongst the team? Another case, the Commission found that in general, what the employer had done was reasonable, but the failure to consult with the employee before issuing the direction was unreasonable. There was, in one case, a recommendation that an employee take annual leave. In that case, the employee didn't appear at the dispute hearing, which are all done by video conference. And so the employer's request was upheld, and that became an order. In another case, an employee with 10 weeks of annual leave and 9 weeks of long service leave refused to take annual leave of 1 day per week, and that was deemed by the Fair Work Commission to be an unreasonable refusal by the employee, and the employee was required to take annual leave 1 day per week. And they considered in that decision, the employee said that they were planning a trip to Europe next year and wanted 6 weeks remaining. They wanted some other leave for something else. The Commission took all that into account and said that this arrangement would still allow those arrangements to go ahead and without adversely impacting on the employee. So the Fair Work Commission will take into account the particular circumstances of the issues for the employer and the employee with these dispute referrals. Another one was a direction for a casual employee to work additional hours. It was reasonable when heard in the first instance. That went on appeal to the full bench of the Fair Work Commission, and it was overturned. And again, it's this question of reasonableness between employees, and the full bench of the Fair Work Commission decided that the direction disproportionately and unfairly affected one category of employee over another. So again, it's that assessment of how are we going to proportion the difficulty and the challenges amongst all of the employees. In another case, a direction to work additional hours was found to be unreasonable because of the employee's other commitments, and again, treating one employee differently. In this case, the employee was a casual worker at a bottle shop, and he was engaged at university, or enrolled at university doing a veterinary course, and his travel arrangements meant that he could only work one shift, which I think was on a Saturday, and then on the Sunday he was travelling back to the university. The employer was receiving JobKeeper payments and then asked the employer to work more shifts to take advantage of the $1,500 JobKeeper payments. And again, it was found to be unreasonable because the employee was working the shifts that they could work and had legitimate reasons for not working additional shifts. So additional hours can be requested of employees, but there can be pushback from employees if they've got other commitments that they have to meet. Just going to employee protections, the direction or agreement under the changes to the Fair Work Act can temporarily override an award, enterprise agreement or contract of employment, but only to the extent of the JobKeeper enabling direction or agreement, and all other requirements of awards, agreements or contracts continue to apply unaffected. So penalty rates, consultation about changes to rosters, all of those usual things that are in the awards continue to apply. When a JobKeeper enabling direction or agreement ceases, the employee's terms of employment will revert back to what they were prior to the direction being given. So you can't say, well, you were full-time, then we reduced you to part-time. We'll increase your hours again, but not back to full-time. They would have to revert back to how they were prior to the JobKeeper enabling direction being put in place. So the timing of this, an authorised direction remains in place until the 28th of September or until it's revoked or replaced by the employer earlier than that. As I mentioned earlier, the federal government is introducing amendments to the legislation to extend these changes consistent with the extension of the JobKeeper arrangements. So all of the arrangements were due to complete on the 28th of September, but there's now new JobKeeper payments that will be introduced from the start of October, and then another reduced payment from the start of February, I think it is. So these proposals, if you take into account that the bill has not passed the Parliament yet, it was introduced yesterday. So this is this information is based on the bill as it is, and there could be amendments to the bill when it goes through the Parliament. But what it's proposing is that the existing flexibilities for eligible employees will remain in force until March 2021, excepting for the request to agree to taking annual leave. And the employers didn't press for that to continue because they said most employers who had requested or who had needed to use annual leave provisions had made those requests already. So that one will drop out, but for somebody who remains as JobKeeper eligible, all of the provisions that I've just talked about will continue for those qualifying employers. So that allows continuing to impose stand downs on employees, perform other duties, change location of work and reduce employee hours. Those things will all continue. The new provision that is proposed in the bill is a concept of legacy employers. So these are employers who did previously qualify for JobKeeper but wouldn't re-qualify with the new eligibility rules for the JobKeeper as it extends past the 28th of September, because there'll be a new turnover test. So those will be called legacy employers, and they can continue to access some flexibilities, but they'll be slightly changed if they can demonstrate that their turnover has declined by 10% in the relevant quarters this year compared to last year. So we'll have two groups of employers who will be able to access the JobKeeper arrangements: the qualifying employers who still qualify in full for JobKeeper, and then the legacy employers who don't continue to qualify but who did qualify previously. So they had to qualify previously to be a legacy employer. So the legacy employers will be able to make job enabling directions for to reduce an employee's hours, but they can only reduce them to 60% of the hours as at March 2020. So you can't direct an employee to stand down to zero under these JobKeeper arrangements. Presumably you would be still able to do that under the normal stand down provisions of the Fair Work Act if you complied with those measures. So that's a separate part of the Fair Work Act. You also can't direct an employee to work less than 2 hours in a day. So there are some protections there for employees, given that these employers won't qualify for JobKeeper, so they won't have had the 30% or more reduction. They'll be employers who've had a 10% reduction in turnover, and consequently there are that they have access to less provisions than they would have had if they had the full JobKeeper arrangements in place. They'll still be able to make JobKeeper enabling directions to perform different duties or work at a different location, including home. So that remains unchanged. It's only the hours of work being a minimum of 60% of previously, and at least 2 hours per day that will be a change. Employer directions which reduce hours for a category of employees may be unreasonable if they have an unfair effect on some of those employees compared to other employees. And we can see this provision being used by the Fair Work Commission to resolve some of the disputes, where they assess, is there an unfair effect on the directions when you compare one group of employees with another. So again, making an assessment of how any directions that you make might affect one group of employees. Again, the legacy employers continue to be able to agree to working on different days and at different times. These are the requests and the issues that are resolved by agreement rather than by direction. Employers will have to give employees 7 days notice of a direction. So this is an increase from the 3 days consultation period. And agreement to take annual leave won't continue for legacy employers. So you'd be back to looking at the normal annual leave provisions of the Fair Work Act and the awards, which is that an employer and employee have to agree on when leave should be taken, and an employee request to take leave can't unreasonably be refused by an employer. And employers can direct employees to take annual leave if they've got excessive annual leave under an award which is over 8 weeks. So those arrangements continue to apply after this. JobKeeper enabling directions will cease immediately if there are two test times to look at the turnover test, that's the more than 10% turnover test, and they are the 28th of October this year and the 28th of February 2021. So if the employer doesn't continue to meet the turnover test on either of those dates, the JobKeeper enabling directions will cease immediately. And interestingly, the way the legislation is drafted, the employer needs to give written notice to the employee before the test time if the turnover test won't be met. So you have to predict that before the 28th of October you won't meet the test on that day, and give written notice to your employees that the JobKeeper enabling directions will cease. The JobKeeper pay rates will reduce from $1,500 a fortnight to $1,200 from late September, and then $1,000 a fortnight from early January. And they'll have a tiered system with lower payment introduced for employees who work less than 20 hours a week prior to the pandemic. So that starts to take into account those part-time casual employees who had a benefit from the original JobKeeper payments, because everybody was getting $1,500 irrespective of hours worked. The new provisions have a 7-day consultation period, which I mentioned earlier, and the employer also has to keep a written record of the consultation that's occurred. So if you were going to enter into these processes, I would suggest using a template to record the consultation that's occurred. The legacy employers will also have to establish a turnover certificate, and that has to be provided by an eligible financial service provider, which is a registered auditor, tax agent or accountant. So you need to actually go through that process of getting another entity to establish your 10% decline in turnover and to give you a certificate to that effect. So just looking at all the other provisions of JobKeeper, or related to JobKeeper, all the other provisions of the Fair Work Act and the awards, other than the changes that I've been through, remain in place, including award obligations to consult with employees prior to redundancy, and the payment of all award terms and conditions for all hours of work performed. We've had some inquiries where I think the pressure of trying to get things changed, some employers have thought that they can avoid some of the award obligations about changing rosters and the like, but there are a lot of provisions in the Fair Work awards that require consultation. Those provisions are all still in place. And as I mentioned earlier, the stand-down provisions of the Fair Work Act, other than JobKeeper-related stand-downs, continue to be available. There's a test there that the employee cannot be usefully employed for reasons out of the employer's control, and that would produce a complete stand-down, as opposed to the JobKeeper arrangements where there's a reduction in hours or a full stand-down. The reduction in hours and a partial stand-down doesn't apply under the Fair Work Act general provisions for stand-down. There's also been some changes to awards. About 99 awards had a new Schedule X inserted, and that provided for unpaid pandemic leave. I think it's 2 weeks of unpaid leave, where an employee has to be isolated or quarantined or undertake a test or whatever, and allowing an employee and employer to agree to annual leave at half pay. So in addition to the unpaid pandemic leave, 2 weeks of paid pandemic leave has been inserted into the Aged Care Industry Awards. So that's the Aged Care Award itself, the Nurses Award and the Health Professional Award for full-time, part-time employees and casual employees employed on a regular and systematic basis. This predominantly arose from obviously the problems in the aged care sector in Victoria. It's not limited to Victoria though, because the Fair Work Act doesn't allow changes to be implemented on a state-by-state basis. So while the Commission said they would impose it in the awards in general, it's not expected that it needs to be used at this stage in most other states, but it is relevant to aged care employees in Victoria. So an aged care trainee or apprentice or nurse health professionals if they had to isolate or quarantine themselves or undertake a test, they can apply for paid pandemic leave. There is a requirement that they actually undertake a test if they've been requested to do so. They also don't need to take the paid pandemic leave if they have access to personal leave. So if they're declared unfit for work because they've got coronavirus, they would be required to take their personal leave before they applied for pandemic leave. If they are awaiting test results or have been requested to isolate, but they're still fit for work, they can't access personal leave because you have to be unfit for work to access personal leave. So you would, in that case, be eligible for paid pandemic leave. There have been some specific changes to awards in relation to the challenges facing particular sectors. So the hospitality award has been changed to allow flexibility. So this is a different schedule to the Schedule X. It's additional arrangements to for the period of the COVID-19. So the additional flexibility is to change or increase the range of duties employers can be required to perform. A reduction of ordinary hours for full-time and part-time employees can be between 60 and 100%. Employers can be directed to take annual leave, which is slightly different to the JobKeeper arrangements, and employers can agree to taking annual leave at half pay. The Clerks Award has some slightly different flexible working arrangements. So again, the range of duties that can be required to be performed can be different to their normal range of duties. The minimum engagement for part-time and casual employees working from home has changed. The spread of ordinary hours for day workers working from home, a temporary reduction of ordinary hours by agreement, and again the annual leave provisions. And an additional one here was a reduced notice period for close down. So if an employer was going to close down completely and use the close down provisions of an award, which generally allow annual leave to be taken, it's a reduced notice because it was normally, I think, 4 weeks or in some cases 3 months. So that's been reduced as well. And then the Restaurant Award was a change again in the range of duties, the reduction in hours, being directed to take annual leave with 24 hours notice, taking twice the period of annual leave, and the reduction in the period of notice for close down. I can't see this one. I think let's see this is the Vehicle Award. The above award was varied, specifically for the issues raised by the vehicle industry employers. So again, a capacity to reduce hours and to consider requests for secondary employment and requests for employers to take annual leave at half pay. And again, the annual leave has to commence prior to the 31st of August for that to be allowed. So all of these changes to the awards aren't necessarily related to being eligible for JobKeeper, but they may be industries that have had an effect because of the COVID-19 pandemic without having those reductions to enable them to be JobKeeper employers. Okay, so I'll just go back. That's the end of all of the information about JobKeeper. I'll just quickly go to a couple of other things that I mentioned at the start. The annual wage decision 2020 was a 1.75% increase to award wages and the federal minimum wage. And I've included in the slides the new C10 rate, which is the rate that most apprentice percentages are derived from, and also just the new rates for the federal minimum wage. The difference with this wage increase is that it was made available in 3 groups of awards based on the effect of COVID-19 on those industries. So you can see from this slide, the Group 1 awards, which were effective from the 1st of July, were really those frontline healthcare and social assistance workers, teachers and childcare and essential services. They were all included in that first group of awards where the rates of pay have been increased. The next lot are ones that are not specifically affected by to the full extent from the COVID-19, but have some effect from COVID-19. So that's from the 1st of November 2020, being construction, manufacturing, and a group of other industries. Now, the expense-related allowances relating to those awards, instead of being based on the relevant consumer price index that would have applied from June, I think it was, they will be the CPI from September for that group of 1st of November awards, and the CPI from December for the 1st of February awards. Now that means that there could be a different outcome between different awards for something, for example, like a travel allowance. The per kilometre travel allowance is was 78 cents and went to 80 cents. If there's a different CPI in September or December, that could give a different outcome to those awards for those allowances that have generally been consistent across awards. The Fair Work Commission has said in relation to that, employers can make application at the next annual wage increase to have that issue dealt with if that's the result of those changes being implemented at different times as a result of this decision. So I imagine that if there are different rates arising, that there will be an application made to bring those rates back into a consistent value across all of the awards. So then the Group 3 awards from the 1st of February are the ones that were most affected by, the industries most affected by the coronavirus, which was the hospitality, recreation, retail, tourism, aviation, those sorts of industries. And again, so for the employers the GTOs that are subscribers to our service, we've put out our updated rates for the 1st of July. Closer to the time when we find out what the expense-related allowances are, we'll put out updated information sheets for those awards. Presumably that'll be in October, and sometime in January we'll put out revised information sheets for the Group 3 awards. So that's the wage increase. For those of you who have labour hire operations, the full bench of the Fair Work Commission has issued a decision dealing with how casual loadings interact with overtime penalties. There's been a lot of ambiguity in the process of reviewing awards about does the casual loading, is it payable on overtime, and if so, does it work on a cumulative basis or a compounding basis? The Commission has been through a whole range of awards and established some principles about how they will interpret those awards, and they're now issuing draft orders to seek to remove the ambiguity in the operation of the casual loading in those awards. So we're just at the moment going through all those awards, and for those who subscribe to our labour hire service, we'll be providing information about how to interpret those. If you don't subscribe to our labour hire service, then you can access that decision and or look out for changes to those awards as they come up in the next few weeks. And finally, the Fair Work Commission has been going through a process of reviewing all of the modern awards, and they've issued 2 tranches of awards now named 2020. There's another group of awards that are still in the process of being reviewed and finalised, and that should occur sometime before the end of the year. There was a big change that occurred in the Building and Construction Award in relation to travel, RDOs and the like. So if you haven't caught up with those, you need to look at those changes from the 1st of July. The Building Construction Award itself hasn't been updated to the 2020 version yet, but I think they were trying to get those other major changes in place and then finalise the award after that. So there's a group of awards being mainly the construction awards and a range of others that will be changed in the next few months. Many of those changes are not substantive changes, but changes to the format of the award and changes to the language, trying to implement a bit more plain language into the awards. So I think that's the end, right? So I'm not sure if we have questions or.
All right, thanks, Janet, for that. As I said earlier, the recording of this and the PowerPoint slides will be made available for everyone. They'll be on our website next week. Happy to take any questions if people want to turn their mics on. We don't seem to have any questions in the chat room.